But now I'm happy to give floor Professor Cayón, who is a professor of philosophy of law in University of Cantabria, where he also serves as a general secretary of the Social Council. And his academic work focuses on the intersection of law and technology, particularly the implications of artificial intelligence in legal practices. So I think we are kind of following what Madis has already started, but probably we will have a bit of different approach. So Professor Cayón, please, the floor is yours.
Thank you. Thank you, Mr. Grover, for your presentation. First of all, I would like to thank the Tallinn University and the School of Governance, Law and Society for the kind invitation to be part of this international event. It's a pleasure for me to be in such a beautiful city and a great honor to have the opportunity to share ideas with such outstanding colleagues. Also, I want to apologize to all of you. Obviously, English is not my language, so I will read my speech to make it more fluent and precise. Excuse me. Well, it's indisputable that artificial intelligence is increasingly present in all spheres of legal activity. The legal profession, the administrative activity, and even the administration of justice, which seems to be now the main focus of attention. I'll tell you that at this very moment, one of the highest grossing films in Spanish cinemas is a political thriller called Artificial Justice. In the movie, the Spanish government announces a referendum to approve an artificial intelligence system to automate and depoliticize the administration of justice, replacing judges in all the country's courts. But the sudden disappearance of the system's designer will reveal a conspiracy to control the entire country from within the justice system. Obviously, the plot of the film is fictional, but the use of artificial intelligence in the administration of justice is already a reality or a legal possibility in an increasing number of countries, including Spain. And my talk is, of course, based only on real facts. Looking at the global picture, we can already see a wide range of artificial intelligence systems designed to automate different types of procedural and judicial tasks at every stage of court proceedings. To mention just a few of the most relevant, we have, for instance, the Pretoria system used by the Constitutional Court of Colombia to select which rulings on the protection of fundamental rights should be reviewed. We have predictive coding tools used in many common law jurisdictions to automate e-discovery. We have the controversial recidivism risk assessment systems used by United States criminal courts when adopting precautionary measures. We have the automatic online dispute resolution systems incorporated by some courts in different countries. And even we have systems that produce drafts of judicial decisions, such as the Argentinian Prometea or the Chinese Wise Judge application. The European Union, aware of the potential that artificial intelligence and other associated technologies have to modernize the judiciary, has placed technological innovation at the heart of its program to reform the administration of justice. Already in its 2019-2023 strategy on e-justice, the European Council specifically designated artificial intelligence and blockchain as areas of priority interest in this field, stating that their proper use can help increase efficiency and trust in the judicial system, and calling for an exploration of the role that they can play in the design of European justice. And the recently approved Artificial Intelligence Act also provides for its use in the judiciary. As we have seen, this European regulation includes among high-risk systems and therefore allows, provided they meet the requirements set for this kind of system, those intended to be used to assist judicial authorities in researching and interpreting the facts and the law and in applying the law to a concrete set of facts. Assist, not supplant. Recital 61 is very clear, as we have seen. The use of AI tools, it says, can support the decision-making power of judges or judicial independence, but should not replace it. The final decision-making must remain a human-driven activity. It thus establishes a reserve of humanity in judicial decision-making. Well, in this context, in December 2023, before the European Act was approved, an Act on Urgent Measures for the Implementation of the Recovery, Transformation and Resilience Plan in the Administration of Justice was enacted in my country, in Spain. This regulation, together with the 410 million euros of European funding to digitize our judiciary, aims to bring about a substantial change in the culture and performance of the Spanish judicial system. It marks a genuine paradigm shift, as it means transitioning from a document-oriented case management system to a data-oriented one. So, from now on, every information and communication system used by the Spanish judiciary must be capable of incorporating and processing information in the form of metadata in order to apply artificial intelligence for different purposes. Among the purposes provided for by this Act is the use of artificial intelligence systems to produce what is called assisted proceedings. Assisted proceedings are defined as those in which an algorithmic system generates a full or partial draft of a complex document based on data that may form the grounds for a judicial decision. In line with the provisions of the European Act, the Spanish regulation states that in no case will the automatically generated draft be a court decision without validation by the competent judicial authority, who will always be accountable for the resolution. In addition, it lays down that the systems used in assisted proceedings must ensure, first, that the draft is only generated at the behest of the judge, and second, that the draft can be freely modified by the judge to whatever extent he deems necessary. And that's all. This is the scant and, by any reckoning, insufficient regulatory framework established in the Spanish Act. This is, of course, almost certainly, because the Spanish legislature were well aware of the imminent passing of the European Act, under which these systems are categorized as high-risk ones and regulated as such. However, there are some fundamental issues relating to the use of these systems that are not provided for in the European Act, and that, in our opinion, require specific regulation before they can be put into operation. Logically, the Artificial Intelligence Act lays down a series of uniform requirements for all high-risk systems applied in very different spheres of activity. But, of course, using a high-risk system to manage traffic, for instance, is not the same as using a high-risk system to assist judicial decision-making. Given the constitutional significance of judging and the importance of the rights and values at stake, the use of these systems must meet some additional or specific legal requirements. For example, in relation to the justification of the proposed ruling or to the safeguarding of procedural guarantees and rights. In light of this situation, let me share with you some questions that I think should be taken into account to ensure that the use of these algorithmic judicial assistants is consistent with the ideal of the rule of law. The first question is, in what kind of court rulings can they be most useful? Because, in my opinion, the potential utility only ever lies in applications specifically designed and trained to operate within well-demarcated legal areas. In this regard, the most appropriate approach may be to start applying them in areas in which the legal criteria are clear and interpretation is largely objective. Administrative proceedings to determine fines and settlements, rent reviews or setting amounts in contractual matters, application of some penalties, compensations subject to complex scales, tax matters, floor clauses and other claims regarding general banking clauses, claims against airlines and other claims in the interest of user and consumer protection, and so on. In short, matters of limited legal impact and economic value that are easy to standardize and resolve quickly. At this juncture, it's worth mentioning how the inundation of Spain's commercial courts in 2022 by thousands of passenger claims against airlines necessitated amendment of the Act governing the judiciary to transfer this court's jurisdiction over such matters also to the civil courts, of which there are many more, in order to spread the workload between all of them. Some areas of family law may also be suited to application of these systems. An interesting use case in this field is the split-up system assisting Australia's family courts in disputes over the division of property, mainly in divorce cases. Split-up is a machine learning system that identifies which property should be included in the distribution and then analyzes up to 94 factors to determine the percentage that each party should receive. In short, operating on a precautionary principle, we think these systems should first be introduced in areas like those mentioned and not be extended to more complex ones until, based on real-world experience, it is possible to analyze their impact on court decision quality. The second question is, what technical characteristics should these systems have? And here we can distinguish between two basic design options. One of them would be to design systems based on the codification of the legal knowledge relevant to decision-making in the legal area. This would entail formalizing a set of concepts and rules, operations that, in our opinion, the judicial authority itself should carry out to preserve its independence. If this approach is adopted, the automatically generated proposals of decision will be fully traceable and explainable according to those concepts and rules established by the judicial authority itself. However, the Spanish Act does not refer to systems based on symbolic artificial intelligence, but only to data-driven systems. As is well known, these machine learning systems generate their outputs using a predictive model created automatically by the system itself and based on the similarities it identifies between the present case and the judicial precedents. Depending on the system design, this predictive model or algorithm can be based on a variety of possible techniques: decision trees, statistical regression analysis, support vector machines, evolutionary algorithms, or deep learning neural networks, among others. And the choice of one or the other of these techniques will determine the degree of transparency and explainability of the system's outputs. Thus, a predictive model based on decision trees can be easily recognized as a representation of a decision-making process in which the algorithm progressively divides the data into subsets according to the most relevant traits or attributes, finally leading to a decision. In other words, there is a logical and traceable route. In contrast, the operations performed by a deep learning model are completely opaque. Well, in our view, it's unacceptable that an automatically generated draft of resolution could be considered adequate grounds for a ruling unless accompanied by an explanation of the rationale that provides a normative justification. At the very least, it should indicate which facts and legal elements have been taken into consideration by the system and which judicial precedents have been deemed relevant. We, therefore, believe that in order for a system to assist in judicial decision-making, it must meet the following two conditions by design. First, the model's predictors must be legally relevant, and second, its outputs must be technically explainable. A system that doesn't meet these two conditions cannot, in our opinion, be applied, even if the Spanish Act does not impose any restrictions in this regard. Besides, in order to ensure compliance with these conditions, the judicial authority must be fully involved in the design, deployment, and training of the systems, and in testing the quality of their explanations. All of this is mandatory in the interest of safeguarding the judicial independence, a requirement enshrined in the Spanish Constitution as a guarantee of the impartiality of the courts and their subjection only to the rule of law. And finally, how should the systems and their outputs be used? Our first consideration here is that under the Spanish law, judicial precedents are not in general binding. So, overestimation of the value of the system's proposals or their acceptance in practice as a default option admissible prima facie may lead to a covert reversal of the sources of law, granting case law priority over legislation. Another risk of reductionism lies in the statistical imposition of majority case law interpretations to the detriment of alternative perspectives. And this could hinder the development of innovative case law. In addition, judges' tendency to follow the system's proposal may also be exacerbated by so-called automation bias. The aura of scientific objectivity that surrounds artificial intelligence can make it psychologically difficult to disregard the system's output. And to this pressure can also be added others of a more practical nature, such as the need to expedite proceedings due to the existence of heavy case loads. So, in our opinion, it's very important to design not only appropriate systems, but also appropriate decision-making environments to avoid the risk of producing robotic or robotized human judges. In other words, judges too much prone or driven by the context to defer decision-making to the machine. A series of technical measures can, of course, be implemented in this regard. For example, the system can be designed to provide not only the proposed ruling, but also another alternative possible resolutions. Network analysis, which helps to detect hidden jurisprudential trends by revealing the complex relationships between the precedents, can also be useful. All of this would provide judges with a much clearer view of the case law, helping them to calibrate the degree of complexity of the case and the diversity of jurisprudential criteria on the legal problem. But apart from these and other possible technical measures, it's essential to provide judges with a specific training on how to identify and avoid the risks aforesaid. In line with the provisions of the European Artificial Intelligence Act, this training should enable the judges, first, to understand the capacities and limitations of the system and to fully control its operation. Second, to make them aware of the tendency to overly rely on the system or overestimate its proposals. And third, to understand the system's outputs appropriately. Concluding, these are just some of the main issues that, in our view, must be resolved before these algorithmic assistants are deployed in Spain, in order to avoid or mitigate their potential negative effects. However, I think that if properly designed and implemented, they can certainly be hugely valuable tools. they can extend judges' cognitive capabilities by rapidly and comprehensively providing them with relevant information about the legal problem, by identifying similarities and dissimilarities between cases, and by presenting the different jurisprudential trends or the positions of different courts on the disputed subject. All of this can help judges to gain a deeper understanding of the legal issues and possible ways of addressing them in order to deliver a much better informed and grounded ruling. In this scenario, the aim should be to build a paradigm of augmented judicial intelligence by harnessing the strengths of both judges and machines. But this paradigm must operate within clearly set bounds, and in no case should the rule of law be replaced by a government of machines. Thank you very much.